Hello everyone, my name is Dwight Mitchell. I'm the founder of Family Preservation Foundation, and welcome to another one of our Child Protection Series Video Defense Pro Se Help Kit. I hope you enjoy the content and allows you to better understand your rights and options while dealing with and involved with CPS. In case this is your first time tuning in and you don't know who I am, after a 22-month battle, I successfully defeated Dakota County Social Services in Minnesota pro se and had my children returned home for me. Although filled with anguish, to say the least, it was an educational experience and I learned a lot. And what this video series is doing is passing along the benefit of my knowledge, my research, the motions I filed, things of that nature, and especially the lessons learned the hard way while cross-referencing the Minnesota State Statutes, case law, which is readily available on the internet and Google Scholar. One of the disclaimers I have to make, although I'm very learned and successful in the law, I am not an attorney. I'm not licensed to practice law, nor am I providing legal services. I have to put that disclaimer in there, but I recommend for you to seek out legal counsel if you can and hire your own attorney. I have a section here on working with your attorney, which is very important. I show you how to get the most out of your attorney and what the American Bar Association requirements are as it relates to your attorney representing you, whether it's a public defender or a private attorney, and these are all the things they don't want you to know. And so I'm giving you that information also to help you along so that you won't be misinformed or misguided like I was by my attorney's legal strategy, which you can really do nothing about, their incompetence and with some and or their greed. So there are some good attorneys out there, but you have to interview them and look at their track record and see if they are exactly who they claim to be, no matter what the attorney is costing or even if the attorney is free. Once they are aware that you know what their requirements are, they treat you slightly differently. What you have to remember is that you're doing this pro se. This video series is for educational purposes only, so I will go over the beginning, the middle, and the end in the entire series. There's going to be a lot of work and reading in this for you, but you're doing it for your family, which is the most important thing there is. You have to learn and understand how to create your own filings, when to file a motion, when the judge or social services or anyone is not telling you the truth. But remember, pro se means you're doing this for yourself, and so you need to really understand this, and you can't go to court and say, well, I read this, or I heard this, or I saw this. This is why I'm giving you the state statutes and everything else, because you have to understand, because you have to do this for yourself. You're not allowed to go in and say someone else did it, because if you do that without cross-referencing yourself, well, then the court's going to take it that that's what you wanted to do because that's what you said to the court. So remember, don't take anything that is said to you for granted. Always make someone give you case law or a state statute or something to cross-reference, and that includes the judges, the social workers, guardian ad litems, or anyone else. So this series, which is probably something I get the most questions on in our parent forum, is should you be a cooperative parent or uncooperative? And that's when CPS says, oh, you're being uncooperative. Well, that's the key question. And what most people don't realize is that there is a time to be cooperative and a time not to be cooperative. And that first 60-day time period is a time not to be cooperative with CPS. The only thing you should be cooperative with CPS on during that first 60 days time period is visitation. You want to see your children, so you have to be cooperative in that sense, but they cannot use your children against you. They cannot blackmail you and say, well, if you don't do this, we're not going to allow you to see your children. That's illegal, and against the law, and I'm going to reference the state statutes as we go through this session right here. So the definition of uncooperative by Merriam-Webster, by the dictionary in and of itself, means marked by an unwillingness or inability to work with others. It also means you're not willing to do what someone wants you to do or asks for, or in the case of us, it's not showing a desire to work with someone in a helpful way. So in CPS, when they call you uncooperative, they're saying, well, you're not willing to help me convict you. And I'm like, you're right, I am being uncooperative. It's your job to prove that I am an unfit parent, and it's my job as a defense to prove that I am. I'm not going to give you any help in proving your case. And that's what most people seem to forget. This is an adversarial relationship. Don't think that you can talk your way out of it. You can explain, oh, if I just tell them I'm just such a great parent, or if I just show them, or if I just take drug tests, all you're doing is playing into their hands. You're giving them, more evidence or whatever to say whatever it is they're going to say. If you don't do anything but prepare your defense and do your visitation plan as you're supposed to, well, then there's nothing that CPS can do as it relates to their allegations. Not unless you truly did do something with it, and that's a different story. Like if you broke your child's arm and it's evident, and your child says you broke their arm for no reason. Well, that's not what I'm talking about. I'm talking about people that are victimized. There's about 7,000 new cases that happen in Minnesota that CPS investigate every year, and about 5,000 of them go through the court system without representation. And during that time, CPS tricks these people into, working on a case plan and cooperating. That's the operative word, cooperating, for CPS to do what it wants to do, when that's not the law. The law says that CPS must prove these things unless you voluntarily, agree or admit to these things and agree to work with them. So, but what CPS doesn't tell you is that they're required by law, within 60 days to prove that you did in fact abuse your child. And if you don't cooperate with them, well, then the onus is on them to get their own facts and make that case. So you're really just waiting for court. So Minnesota Statute 260C 157, there's the investigation that CPS needs to go through. So that's their state statute saying that they have to go through and do their due diligence and investigate any allegation. So if someone calls and says, hey, so-and-so's beating their kids like crazy, well, CPS has to do a thorough investigation, whether it's false or not. And a lot of people do that now. They'll get mad at someone and they'll, call CPS on them. And that's like just a horrible thing to do, because these people really don't understand what they're doing or what they're putting these people through, especially if it's false allegations. Because CPS automatically believes it to be true if someone, calls in and states that in the first place. So if it comes within the court's jurisdiction, which is State Statute 260C.101, well, then they're required to investigate it. So if CPS files a petition in juvenile court, the parents have a right to a trial within 60 days, where CPS has to try and take these allegations and prove them. A parent should always deny the allegations no matter what. And I feel CPS, if the onus is on CPS to prove that you're an unfit parent. So my recommendation, and this is my own opinion, everyone has one, you always put in a denial and let CPS come back and prove their case. If the parent and or a child over 10-year-old, it does have a right to legal counsel, so that you do have the right for a lawyer. Something else you should be aware of is that you must have a pretrial. This is the scheduling of that first trial within 10 days of your admit deny. So you'll have the EPC hearing. 10 days later, you'll have the admit deny. And 10 days after that, there's a trial where they must schedule your trial. And that's when people should just stop and start preparing your defense. whatever else CPS has to do, let them do it. But in 60 days, a trial is supposed to commence to you. Look at the handout that goes along with this slide. I lay everything out for you. This is the order it should go. Boom, 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 according to the timeline. And until you get your trial, you do not have to cooperate. You do not have to do a case plan. The only thing you need to do is visit your child. That is mandated by law. CPS cannot stop that. They might take it down instead of 2 or 3 days a week to 1 day a week, but whatever it is, make sure you don't miss it and make sure you continue to do that, because that's what's supposed to happen. At your trial in 60 days, if the judge finds you guilty, meaning if CPS does present evidence and the judge finds you guilty and the child is adjudicated CHIPS and they keep that child in foster home, then and only then are you required to cooperate and participate in that case plan, because now you're ordered to do that. I have not been able to find any Minnesota state statute that says that a parent must cooperate with CPS, and I've been looking for a long time. As a matter of fact, what I find is just the opposite. So, simply stated, you have the right not to self-incriminate yourself. It includes the right to remain silent. You are not required by law to help CPS prove its case at all. Don't let CPS tell you you are. Don't let CPS tell you you'll get your child back faster if you cooperate and help with them. As a matter of fact, it's the exact opposite. Every single parent I know that cooperates, it takes them longer. When we won the Amanda Weber case, we did not cooperate with CPS at all whatsoever, and she got her child back in 60 days because they could not prove their case. Never sign any release forms at all. The only release form, if you sign anything, is for visitation. You make sure that it's narrowly defined and it says this is for visitation only. And if they don't write it on the form, you write it on the form. This is for visitation only, this release. You can release information between the visitation supervisor and CPS and no one else, and that's it. So it is your right to prove that you're innocent in 60 days. And it's their CPS's right to try and prove, if they can, that you're guilty. So if you're uncooperative, it prevents CPS and the caseworkers from gathering enough information to substantiate the allegations against you. The caseworker will have to consult with the attorneys representing CPS, county attorney or whatever, and if they can't substantiate the allegations, well, the county attorney is not going to go to trial and try a case where he has no evidence. So if they have no evidence, they have no choice but to dismiss it. So CPS has taken your child or your children away from you. You're trying to get them back, not provide CPS with any aid in keeping your children any longer. So keep that in mind. Under the Fourth Amendment, you are protected from unreasonable searches and seizures. Not only does the Fourth Amendment apply to CPS and what transpired in any of the civil cases, there are some exceptions. When I say some exceptions, like if someone calls 911 and says your child is dying, well, in that situation, CPS or the police are allowed to come into your house without a search warrant, because that's supposed to be exigent or an emergency situation. But outside of that, if they're asking to come in, just say, no, I'm sorry, unless you have a search warrant, you cannot come into my house, and leave it at that. You don't have to be rude or anything, but take this as, for what it's worth. If CPS is at your door, they already believe the allegations. They're there trying to collect and grab evidence against you. So you don't have to do that. Never let CPS in your home without a search warrant. If anything, walk out on the front porch and talk to them. I mean, even as a private citizen, not dealing with CPS at all, if the police come to my house, or if anyone comes to my house, not just the police, I don't say come on into my house unless you're a friend and I invite you over for dinner. Whoever comes to my house, the plumber, whatever, I walk out on the front porch first. I verify their credentials. I talk to them. But you don't get into my house. That goes double for CPS or the police. Now, here is the biggest thing that I don't understand parents, but they do it anyway, so I'm here to tell you this. CPS needs your consent to drug test you. They cannot drug test you unless you agree to a drug test. People, will you stop doing drug tests to try and prove your innocence to CPS? Don't let them say to you, well, if you were innocent, you take this drug test. Say, no. It's the other way around. You're saying I take drugs. Prove it. Well, you can't prove that a person takes drugs unless they consent to a drug test. That's the law. So now there's an exception to that one also. Say you're passed out on the street and they're trying to give you some emergency treatment and they take a blood sample trying to figure out what's wrong and they find out that you're full of drugs. Well, in that case, they already know because it was an emergency situation. But that's not the norm, you know. The norm is they cannot force you to take a drug test because they don't have the legal authority to do so. And don't let CPS tell you otherwise. They will notify you that if you don't take a drug test, it may go against you. Tell them fine. They're going to try and get you drug tested as soon as possible because they're trying to dig up anything they can on you. So within that first week or two, they're going to say like, you know, I want you to take a drug test. You're like, I respectfully decline to take a drug test. I'm not taking a drug test. You know, write it up any way you want, but I'm not taking a drug test. There are certain states that do try and drug test every single person, but here again, they need your consent. You know, they just can't take it. They will try and ask everybody, but, you know, the unwitting, you know, unknowledgeable parent is just going to be like, okay, that's just opening up a Pandora box. Even if you're clean, it's like, you know, it's a matter of principle. And some people will say, well, you know, if it's a matter of principle, it shouldn't matter. Well, that is your decision. I can't tell you what to do in that regard. I know that I'm not taking anything against my will. That's just me, you know. So you have to decide what you want to do. I'm here to tell you that even if you take a drug test, it's not going to help you. It's not going to help your case at all. If anything, if what you want to do is prove that you're a clean, sober person, when you go to trial, you go to 2 independent labs, 2 hospitals, and you get 2 drug tests, and then you submit that as part of your evidence that you have no drugs, alcohol, and that you're a clean, sober person. So they can't try and use that allegation against you. You sort of are nipping that in the bud. But you only do that at trial. You don't have to do it before then. You know, so at that 60-day trial, when you're doing your discovery and exchanging evidence, you're like, oh yeah, by the way, here's the test to show that I don't do drugs or alcohol or anything of that nature. Your children can be drug tested, and the reason they can be drug tested is because technically if they're in foster care and the state is trying to provide services, they have to understand your child's medical needs. So, you know, they can get a court order to talk to the judge about your doctor about your child's medical condition and things of that nature, and they can do a blood test, but that's because they have to make sure that they're doing things safely in case your child has like a peanut allergy or something of that nature. There are millions of rules that govern tests and what can and can't be done for every different situation. I gave you 2 today. And you should know those rules as it pertains to your rights. But by and large, you don't ever have to consent to a drug test unless they already have evidence that you're a drug addict or, you know. So a lot of people say, well, what happens if I refuse to take a drug test? So if you refuse to take a drug test, the investigator will assume that you're using, because that's the way they think, and they will act accordingly. And when I say act accordingly, they're going to write up that, you know, you're uncooperative and you refuse to take the drug test, but that still doesn't give them hard facts or evidence to say that you were. The investigator may try and get a court order for you to take a drug test, but there has to be a valid reason, meaning they just can't go to the judge and say, I wanted to take a drug test, you know, and the judge has to say, well, why? What are your grounds? You just, you know, you're taking away a person's constitutional right and liberty. So you can argue that case also. They just can't make you take one for no reason. And if a drug is saying that, the judge is telling you to say that, you could tell the judge, Your Honor, no, I'm not taking a drug test. I said, there's their job to prove at trial that I do drugs. And, you're taking away one of my liberty interests, and I'm not going to follow your order. Now, he might hold you in contempt or whatever, but if you're respectful and you tell him respectfully, say, I don't have to do that, and that's not the law. Show me the state statute or the case law, Your Honor, and then we can talk. Judges, will order things all the time that are illegal, and then they have to, backtrack later on when it goes to the appellate court and things of that nature. But even if a judge tells you you got to take a drug test for no apparent reason and there's no facts surrounding it, you can respectfully decline. Don't, to take that. The investigator is going to say to you, well, people who are clean never refuse to take a drug test. That's just an old trick that they use, well, if you have nothing to worry about, you take it. And I'm just like, I'm not. People have false tested because they're taking like an over-the-counter drug, or they'll take like an antihistamine or something of that nature that will give a false positive. So don't let that trick talk. And that's what I call it, convince you into taking a UA because you're like, I got nothing to hide. I have had people in our group who have tested positive, for something else, not actually an illegal drug. So don't do that. So if there are allegations of drug use, as I said before, and I'll say this again, go get your own samples from 2 independent labs, bring them to the court at your 60-day trial. Don't do a drug test before. Make sure it's a skin scraping or hair follicle test that you bring to the court. Make sure you take 2 with you, so that way that they can't say, well, you only did one. This one could be false. If you have 2 tests from 2 different labs, then that's unrefuted evidence that you don't take drugs. What may happen if you do cooperate, as I said, is if you're accused of not supervising your child, or a worker asks you questions about like drugs or alcohol or pornography or whether you've had an abortion, you don't have to answer those questions either. They call themselves being thorough in that what they're trying to do is that not only are they trying to screen out the original allocation, which it could just be a spanking on the behind, so they're not only trying to gain evidence for that, they're trying to gain evidence for anything in the CPS spectrum that they can use against you. So if you don't cooperate, when they ask you questions like, do you feed your kids every day? Yes, I feed my kids 3 times a day. What do you feed your kids? It doesn't matter what I feed my kids. I feed my kid a healthy meal 3 times a day. And just, leave it at that. No, I never leave my kids unsupervised. No, I don't do drugs. No, I don't do alcohol. No, I don't look at pornography. No, I've never had an abortion. Whatever they tell you is no, 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 no. They need to come and prove it. And I'm not, as I said, these are just my opinions. I'm not your lawyer, so your lawyer might tell you to do otherwise. It's up to you. The ultimate decision is yours, because your lawyer is supposed to listen to you also, in everything you say. Never let your lawyer tell you, well, you need to cooperate. No, you don't. Tell your lawyer, show me the law that says I need to cooperate. There isn't one. Social workers will screen the children, and they'll ask the children all these questions also. Do your parents do drugs? And, have your parents beat you? Do your parents send you to bed with no food? And so on and so forth. And they're allowed to do that. They're allowed to interview your children without you being around. They're allowed to ask your children all these questions. As I tell most parents, there's nothing you can do about it. Don't lose your mind. The parents are like, oh my God, there's nothing you can do. They still, have to prove their case in court. So keep that in mind. They're screening for all risk, not just what was called for. So when they start asking you all these questions, just answer them and just say no, 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 to whatever they're saying. Some people think, well, let me be honest and tell them I'm like, your job is to defend yourself. Your job is to remain silent, especially if you don't have an attorney. And remain silent to your trial, and only at your trial then you have time, because that 60 days it gives them a chance to try and collect evidence. It also gives you a chance to prepare. It gives you a chance to read, to understand your rights, look at the case law, to see what they can do, and to put together your trial preparation without messing things up. A lot of parents will open their mouths thinking they're doing the right thing, and all they've done is just made their case that much more difficult to win. So please keep in mind that it is better for you not to cooperate and to be silent and wait and hold everything for the for the trial. And so, with that, there are many times that the original allegation cannot be corroborated, meaning someone says you hit your child, CPS comes out, and they look at your child, and your child's fine. There's no bruises, there's no marks, but they're out there, so they're going to see if they could find something else. So they call themselves doing a thorough investigation. That is as it may be. I can't tell you, but if you come out, in my humble opinion, and investigate, for one thing, to be looking and digging and searching for other things, that's what they do. That's the law. That's why they're trained to do these things. I can't speak to why. I know they call themselves doing a thorough investigation. One of the things that they try and get people on is neglect. 84% of the people that are in CPS are for neglect, and neglect is so broad. That's why I tell parents not to cooperate and to be quiet. So if they come out for a spanking, they can come out and say, "Oh, neglect is dirty dishes in the sink." I've seen this, the CPS in write-ups. Oh, they had dirty diapers in the garbage, or the refrigerator didn't have enough food. Well, it was the end of the week, and husband was going food shopping, and whatever the case may be, they will use whatever they can to try and put together a case. So don't let them in your house. Don't talk to them. Neglect is the broadest case, and almost everything falls under neglect. Things that you think are just benign that you wouldn't even think about are in this neglect category. So if you don't let CPS into your home and you don't take a drug test, there's nothing CPS can do about that. Read the handout again. I laid it out in detail. If you refuse, you refuse. There's nothing they can do. They can tell the court you're being uncooperative, but that is your right. That's your constitutional right. They do have a right to see your children. So what I tell a lot of parents, if they want to see your children, just say, "Fine, I'll bring my children down to the CPS headquarters tomorrow. Let's make an appointment. That's the time. But you're not coming into my house to see my children. I'll bring them to your office tomorrow, and then you can see see my children and see that they're healthy and that they're okay." So that is one way to get around not letting them in your house and not letting them in drug tests, to make an appointment and go take your children down to the CPS headquarters and let them look at your children and say, "See, my children are okay. There's nothing wrong with my children." So what happens if you don't cooperate at all? You need to cooperate at visitation, as I said to you. But if you are completely uncooperative and you don't do anything, if you never see your child for visitation, that's a big problem. But if you don't let them in the home, or you don't let them talk to anyone, or you don't let them talk to your relative, that's going to throw up a red flag for them. But you really don't care about their red flag. As I said, this is adversarial. This is CPS against you and your family, and they're in there trying to mess with your family and your business. And guys, the only way you're getting in here is with a fight. And that's just the way it is. CPS will go away if they have nothing. They have no choice but to go away. If you're completely uncooperative, they can't prove their case. They go to the county attorney. They're like, "I got these allegations, but I got no proof to back up the allegations." Then the county attorney's gonna be like, "Well, you're gonna have to dismiss it. Close the petition out because I can't prove anything." But CPS will go away, but make sure that they don't come back again, because they're going to red flag that folder, and if they do come back again, then they're going to sit here and try and work double hard to prove the allegations the second time. So if you're really not hiding anything, you really shouldn't worry about it. I don't think they'll come back. I mean, but these are things that you as a parent need to do and understand and figure out like what to do, because every case is different. I can't talk about every single scenario. This video and this handout is giving you the basics. Now, if you're doing things, you have to figure out what's going on, but don't start lying, and it's better just to politely refuse than to lie about it, and let them prove it. Legal responsibilities and resources. So they can contact your children's doctor, as I said, because they have to maintain your child's health while the child is in your custody. They cannot contact your doctor, without your legal consent. They can't contact doctors, counselors, anyone that you're dealing with, because you're an adult. They need your written consent to do so. And my opinion again, you should not do it. Bring your doctor's written case reports, have them come to court in 60 days and testify in your behalf, but don't let them talk without you. If they want to talk to anyone, you make sure it's through a deposition and through legal channels and through a subpoena. Nothing is voluntary. Talk to your doctors and lawyers and say, hey, if anybody calls you, contact your attorney and make sure it's done legally through a subpoena or for a deposition. Other than that, I'll see you in court. Ask your doctor or counselor to speak with your own attorney, if you do have an attorney, to better prepare and present your case and your defense. Advise your doctor that if any other lawyer calls outside of your own lawyer, to refer that doctor to your lawyer, but not to speak to that person about yourself. You do not give them permission to talk about you or your case or anything of that nature. If your doctor receives a subpoena, have your doctor immediately contact your lawyer so your lawyer can be at that deposition or subpoena, because that's the law. Advise your doctors or your counselors or anyone else that all communication should be through formal legal channels. Do not talk to anyone on the phone whatsoever. I'm going to tell you something that happened quickly before I end this, is that in Amanda Weber's case, the county attorney didn't have any information on Amanda Weber at all. So what she was trying to do is to go behind Amanda Weber's back and talk to the doctor, by herself on the down low. And since Amanda Weber had already talked to the doctor, what the doctor did is refer the county attorney to her lawyer, and her lawyer says, well, if you give us a formal subpoena or you subpoena us to come to court as a witness, then and only then will I talk to you. So, the county attorney was and the CPS was in a difficult situation because they had no evidence. And then when the doctor came to court, the doctor said, no, there's nothing wrong with Xavier Weber. He's a healthy kid. There's no issues with him. So it totally screwed up CPS's case, and CPS couldn't lie and try and twist and turn the doctor's words or findings. And so that's one of the benefits of doing what I just told you. It successfully works, and it's helped in our cases, and I hope it helps you also. Well, that's all I have to say now on being cooperative and uncooperative. Read the handout that goes along with this. I hope this was informative and gave you a little bit of understanding on what you may or may not do. I can't tell you what to do. I can only tell you what I did in my case. In my case, I was totally uncooperative. And when I finally got my say in front of the judge, I made CPS look stupid. So, I just wish I knew then what I know now, and I wouldn't have let all this time go by. I didn't know about the 60-day time frame. My lawyer didn't tell me about that, and so there were all these things that were going on that I wish I had known that I'm sharing with you. But everything I learned in my case, we applied in the Amanda Weber case, and we got her child back at that 60-day trial. After the trial, a judge was like, got to release the child. There's nothing wrong. But they kept trying to get Amanda to cooperate and do the services and do this. And I tell everybody, if you cooperate, you shut off the trial clock. And that's how I'm going to end this. They have to give you a trial in 60 days unless you voluntarily cooperate and agree to do the safety plan. And then it goes from 60 to 90 days right off the bat. And that's when they have their first review. They're going to say, well, let's see if the parent is cooperating. And we aren't going to have a trial now where we have to prove the parent was wrong. Now the parent has already said they're going to do the safety plan, so we don't have to do the trial. We don't have to prove they were wrong, and we can just keep the child. So look at those state statutes I gave you. They're very beneficial. Thank you very much. Look forward to seeing you again in our next video series and providing you with some additional information and helping you against your defense and fight against CPS. Have a great day.